back in session. Parties of council are present. Our jurors are not yet present. Council indicated you had something you wanted to address before we bring the jury in.
Yes, Your Honor. Defense wants to make an objection at this point, and I think we're going to have a hearing. Last week, we received discovery requests from the district attorney's office, and then they also contacted our experts directly. I told them, do not contact our experts for discovery. All discovery goes to attorneys. For product issues, there's issues of whether or not we're calling a witness or not. Those decisions haven't been made yet. This morning, Mr. Ahn, over our objection, contacted our experts, telling them we want all notes, we want all reports, we want everything that you worked on in this case, and in direct violation of the defendant's right to Sixth Amendment right to counsel and work product. That is a direct breach and direct violation of a request of attorneys to not do discovery on their own, to go through counsel. If they have a problem and they don't think they have everything they're entitled to, the proper course is to contact the court and ask for the court to get involved to order discovery, not to take it upon themselves and breach the defense team. We want an order of the prosecution to not do discovery on their own outside of counsel or the court, and we're looking at maybe sanctions. And this might be something that's reportable to state law.
Oh, let's have that hearing. Let's go.
Let's do it.
Well,
I would love to.
We're not going to do it right now, but.
Well, Your Honor, there has been multiple requests of the defense that they have failed to comply with. So apparently they're taking the defense tactic of ambush defense. So they declared them as witnesses in their opening statements. They provided their CVs and a limited amount of discovery as to certain witnesses. And despite those numerous requests for reports from these people they've declared to be witnesses, once they provided counsel with a proposed witness list of 44 people that included those individuals, yes, I contacted them via email for any of the material that the defense has failed to supply. There is no legal bar to us contacting someone who is a potential witness in a case to either interview them, schedule them, get other materials for them, provide them materials. So, actually hearing some legal authority for this proposition, the fact that they've declared them a witness multiple times and had them sitting in court during other witnesses' testimony, declared them an opening statement, provided some discovery already. I think the cat's out of the bag of who's a witness and who's not. Therefore, we have the right to discovery of certain material that the defense is refusing to turn over despite numerous requests over numerous months.
Well, certainly each side is entitled to contact witnesses that the other side may be intending to call to interview them or to provide them with additional materials to review. Requesting notes or materials that they have probably is something that should go through counsel, but I don't know that there's a legal requirement for that. So,
I cited legal authority to them how they must go through counsel. That is the understanding of all discovery requirements. The idea that we're declared witnesses. This is not civil court. If this was civil and we had to declare experts and declare witnesses so they couldn't do a trial by ambush as the people have done this entire case, and they'd have to provide that information 30 days before trial, there'd be a cutoff of experts, there'd be a cutoff of witnesses because they weren't declared. We would embrace such a practice, but that's not the practice in criminal law. We have not declared anything. I said in my opening statement, these are the experts that we had involved in our team. At no time did I say what they were testified to. Even if I did, that does not make them an automatic witness. Giving a proposed witness list does not mean I'm calling them.
all right, if you want to schedule a hearing for prosecutorial misconduct, we'll schedule that hearing, but we're not going to do it now to interrupt testimony of witnesses. I have no problem with either side contacting witnesses that may be called by the other side and attempting to interview them, provide, if they're experts, provide them with additional information to review, as it may affect their opinion and so forth, whether or not you can then request from them, well, give me all of your notes and reports. It is something you would be entitled to. Whether or not that should have to go through council first, I'm willing to look at it
Your
either.
Honor, also just, council knows that whatever, let's say for example, in this case.
I'm not gonna discuss it any further right now. You wanna schedule a hearing on that, we'll schedule a hearing, you can file your motion. Okay? You ready to bring in the jury then?
Sure.
We were
Okay.
missing one, I'm gonna check and see if he's
Oh,
arrived.
okay.
Not yet, he texted, said it was about 5 hours.